This is Musings and Counsel from London Baker Law with Debbie London Baker.
What are some of the documents that make up this plan, this estate plan?
So the will we talked about, that's called where you do your bounty. But the ones that exist now while you're alive, or your power of attorney, which is where you give somebody access to your financial wherewithal. They can go to the bank and write checks on your account. They can access your account. If you choose, they can change beneficiaries on those accounts. Something that we put in is a clause that allows that if you need Medicaid planning, which is not necessarily age, Medicare is age-based, Medicaid is not necessarily, but if you experience a situation where you need governmental support for long-term care or something like that, your power of attorney can do that. So it's all the financial aspects for your power of attorney. Your healthcare surrogate is just that. It's you naming somebody who can make healthcare decisions for you. They can never override you as long as you have the mental wherewithal to say, what are you thinking? No, doc, we're not doing that. You have precedent. But the thing is, I know I recommend people sign them to go into effect immediately, because if your loved one's in a car accident and they can't decide, they want somebody to be able to decide. And that person also has access to your medical records. Then they have a HIPAA waiver, where we're probably all familiar with HIPAA and privacy. And that's where you give people access to information. So again, let's say we're siblings and there were three others, and I'm the healthcare surrogate and you're my backup. Our parents might give the other three siblings access to talk to the doctor, not to make a decision, but to talk to the doctor. And I ask clients, do you want the rest of them to be able to talk to the doctor? No decisions. So that's your HIPAA waiver. Those are the four basic ones. In Florida, I do a pre-need guardian. So if you become incapacitated to the point of needing a guardian, you've already named who you want. So again, the family doesn't go to court and say, no, mom wanted me. No, mom excluded you, actually. Read the document. And the last one that's part of the basic plan is a document the living will is how do you want to die? So at what point do you want the doctors to pull the plug, so to speak? So that's the living will. That's part of the basic. But there's one about what do you want to do after that? Do you want to be buried? Do you want to be cremated? Where do you want to be scattered? Where do you want to be buried? Do you want something special in terms of religious observance? What do you want? I have somebody right now who her husband wants his ashes scattered at a wildlife management area in upstate New York. Well, probably that's not allowed. So the language will say as allowed by applicable law, because they need to be on warning that be careful. And I don't want them coming back to me and saying, we told us we could do this. No, I didn't tell you could do that. It says as allowed by applicable. So my first mentor taught me that. That's what you put that in. Any place somebody wants to be cremated and ashes scattered other than someplace So those are the basics.
This has been Musings and Counsel from London Baker Law. Learn more at londonbakerlaw.com. Thanks for listening.